Thank you all for joining us today. We are excited about this webinar on special needs financial planning, as it is an important subject that we all need to learn more about. Steve Ehrens is a wealth management advisor with Northwestern Mutual. He is also a passionate advocate for his daughter, Elizabeth, who is 29 and has special needs. I first met Steve when he spoke at our daughter's school. In fact, he often addresses groups in the New York metro area about special needs trusts, and now, through the power of Zoom, you are all able to take advantage of his expertise. Steve helps empower parents and caregivers on the value of developing a special needs trust life care plan, understanding the laws around special needs trusts, ABLE accounts, applying for SSI and Medicaid. These all take time, and there is a learning curve with regard to the process. Steve is here to help us with this all-important journey. As a parent of a child with special needs, he has gone through the process himself and understands our struggles. Sunitha Malapati, the Vice President of the CAC-1A Foundation, will be monitoring the questions. The information provided by our speaker during this webinar is for informational use only. The CAC-1A Foundation encourages all attendees to consult with their own professional advisor about any advice that may have been mentioned as a part of this webinar. And products or services mentioned during this webinar do not imply endorsement by the CAC-1A Foundation. Welcome, Steve.
Thank you, Lisa. Thank you so much for having me here. Well, thank you all for taking time out of your busy days. I am going to talk to you a little bit about planning for the future of your child with special needs. As Lisa mentioned to you, I also have a daughter with special needs. Her name is Elizabeth. I'm going to talk a little bit about her. I am a CPA and a wealth advisor. I'm with Northwestern Mutual, and I am in Fairfield, Connecticut, and I've been practicing for over 25 years, working with families like myself who have children with special needs. So I want to tell you a little bit about my story. So this is my daughter, Liz. Liz is now 29 years old. Liz was an in vitro twin. Her typical sister's name is Jessica. After 5 long years of working to have kids, we hit the jackpot with 2. And Liz, when she was born, was 1 pound 9 ounces, 12 inches from head to toe. She spent 3 months in the neonatal care unit at Yale New Haven Hospital. And when we took her home at 3 pounds 9 ounces, it was the smallest baby ever that was discharged from Yale New Haven. But they told us, bring her home, feed her, she should grow, and she did. Now she's a whopping 4 feet 8 inches tall. She's a great kid, and we have a lot of fun together. When I wrote this slide, I said, how will she transition to a rich, productive, and fulfilling life? Of course, that's what we all want for our children with special needs. Some of the concerns that we've had along the way, which I'm sure most of you have thought about, are being outlived by our children. So I'm actually 35 years older than Liz. And I know that I won't be here forever. And what's going to happen when I'm no longer here? She has a twin sister, Jessica. And as much as I want Jessica to be involved with Liz's life, it's really not Jessica's responsibility to care for Liz. It's my responsibility. And I just don't want to pass on too much responsibility to her. I'm worried about changes in state and federal laws and regulations. I know what the benefits world looks like now. I know what Liz is getting in benefits. I also know we're in a country that's running out of money, and who knows what's going to be 20, 30, 40, 50 years from now when I'm no longer here in terms of benefits that are going to be available for Liz. Ultimately, I'm concerned about providing for her a lifetime of care and support. And I'm also worried about lifetime of care and support for myself and my wife. Some of the decisions that I've had to make along the way that I'm sure all of you are thought about is who would be her legal guardian if something were to happen to us. Where would she live? I'm fortunate that I don't have significant medical expenses for her, but I do still have significant ongoing expenses for her. She does take medication. And what's going to happen when she's no longer on my medical insurance plan. So I have to think about that. For many of you, you may have significant medical expenses that will be ongoing for your children. How will those expenses be funded? How will the kids be cared for? Ultimately, I'm concerned about how her needs will be fulfilled over her lifetime. And what if my wife and I, as I mentioned before, what if we need care? Who's going to care for us? And if someone or we are being cared for, how will she then be cared for? So these are some of the decisions we've had to think about along the way and try to figure out in terms of planning for our future and also for her future. So what we typically do here is we try to sit with families and we try to assess your situation. First, we'll try to set some goals. What are we working towards? We'll typically assess your situation, and everybody's situation is typically very different. Then we'll develop a plan and we'll help you all implement the plan. And of course, we want to keep that plan up to date. One of the things that we see is that everybody's situation is changing all the time. It's hard to know what the future is going to be. When my daughter was born at 1 pound 9 ounces, I had no idea what her future would be. When she was 13, I really had no idea what her future would be. She's now 29. I finally feel like I've got a good idea what her future is going to look like. And the key to my planning has been flexibility. So no matter what happens in my life and her life, the plan we've put in place is flexible enough that it can provide that safety net should we need it. But in the unlikely event that we don't, at least we've done some things that will benefit all of us, not only Liz. So flexibility is the key to success when planning for the future of your child with special needs. And what you need to do is you need to go out there and you need to try to find some professionals that you can work with, that you're comfortable with, that you're going to be relying on for the rest of your life, that you can go to on a regular basis for advice. I call it your own personal board of directors, and that might include some family members who might ultimately be your caregivers, financial professionals such as myself who are experienced in special needs of planning, financial professionals also for the family that maybe can help you with your own planning, such as retirement planning, medical professionals, social workers, attorneys. There's lots of different attorneys out there. Many of you have possibly already worked with advocacy attorneys or real estate attorneys. If you're putting together special needs trust, you'll need an estate planning attorney. So lots of different attorneys at lots of different levels that you'll need to interact with. CPAs, very important that you work with a CPA who's got some experience in special needs planning, because there are expenses along the way that you may incur that may or may not be deductible. And you want to make sure that your attorney understands all the implications of where and how monies are being spent. Of course, public and private agencies. But we need to talk a little bit about benefits as sort of the starting jumping off point for planning for the future. So probably the first and most significant benefit, which many of your kids may already be receiving, is SSI, Supplemental Security Income. And in order to qualify for SSI, first of all, you've got to have an individual, a child, with a Social Security defined disability. And you can go on to the Social Security website. You can see what these defined disabilities are, but that's obviously critical to the overall process. The second thing is that your kids can't have more than $2,000 of assets in their name. If they do, they would be immediately disqualified. So for example, if you've got a 529 plan set up for your child, or you've got a Uniform Gift to Minor Act custodial account for them, or you have savings bonds, or any kind of different accounts that have more than $2,000 in them, that would then disqualify your child from receiving SSI. So assuming you qualify, the maximum monthly benefit that the kids would be eligible for is $794, and this would come to them and it would be non-taxable. And of course, one of the things that happens is if they're earning money, that benefit would then be reduced 50% for every dollar that they earn. So a lot of people are constantly keeping in check the amount of money their kids are earning so that they don't lose that SSI benefit. The purpose of SSI is to provide the kids with money for food and shelter. So the money is given to them not so that they can accumulate it and invest it and keep it so that it grows. Of course, if they did that, they would then lose the benefit because they would quickly grow to over $2,000 in assets. But the purpose of the money is ultimately to be spent for their well-being. And what many families do if the kids are getting this benefit is they essentially bill their kids room and board if the kids are living at home as a way to transfer that money out of their kid's name into mom and dad's name. So the money moves from the child with the disability to mom and dad so that the child can continue to receive the benefit. The next benefit that's out there that is a significant benefit is Medicaid. And Medicaid has a whole host of benefits that would be available to the kids. And Medicaid, the amount of assets that the kids can have varies by state, but it can in many cases be less than the SSI minimum of $2,000. It can be as low as $1,600. And again, if your kids were to qualify for Medicaid, it can provide a whole host of benefits. But the two biggies are, first of all, medical benefits. And medical would be insurance for going to the doctor, or if they need hospitalization, or whatever the medical benefits are that are available to them. And the second major benefit could be housing. So for example, if your child was to end up going into some kind of group housing situation, or there are also housing supports. So those would really be the two largest benefits, insurance, medical insurance, and housing support. And I just want to touch on medical insurance for a minute, because unfortunately, Medicaid is really bottom of the barrel in terms of medical insurance. And many providers will not even accept Medicaid. And just to give you an idea, if you were to go to a doctor, for example, and go in for a checkup, your private insurance policy might provide that doctor with a payment of, say, $200. When you turn 65, you would go on Medicare. Medicare might provide that insurance to the doctor who might do that physical for you. They might pay them, say, $125. Medicaid, on the other hand, if your child were going to that doctor and getting a medical, a physical on an annual basis, might only pay $35 or $40. So because of this very low payout rate, many doctors will not accept Medicaid. Just as a point of information, when you work for a company and you have your children on your medical insurance, it's typical that your children are required to roll off your medical insurance when they turn 26. But it is also possible that you can get a waiver. So Liz is now 29, and I have insurance through my employer with Blue Cross Blue Shield. I also was able to successfully get a waiver, which allowed Liz to stay on my medical insurance. So Liz is getting Blue Cross Blue Shield, even though she's age 29 and typically would have had to roll off. And if she did roll off, then she would be on either Medicaid or she would be on insurance through her employer. But because she works part-time minimum wage, which is very typical for kids with special needs, she's actually not getting any benefits at all. So that's not an option. But another option might be to go onto the Affordable Care website, Obamacare, that might offer a medical insurance program for her that would be at a fairly high cost. So for everyone who's listening, just be aware that there is the potential to keep your kids on your medical insurance plan through your employer beyond age 26 if you can get a waiver. Now, all of that being said, it's all great, except that I am soon going to be 65 in 2 more years. I'm 63. So the question then will be at 65, when I go on to Medicare, what then will be for Liz? Will I go out and buy her insurance? Will I just leave it be that she's got Medicaid, which I know is already going to be a problem? Or will she possibly be working for an employer where she's provided medical benefits? So this medical issue is a big concern to me. It's a big concern to many of the families that I work with, and it's something you all need to think about. Now, there are other benefits out there as well. SNAP, which is food stamps is a program. Of course, you have to be eligible based on the amount of money that you earn, and if you earn too much, and I think it's around $1,400 is the cutoff. And there's lots of programs also offered locally that you would become aware of based on where your child is living. So one of the things that we all want to do is we want to make our kids eligible for everything that we can that's out there in the world, in the state and federal benefits world. We want to make them eligible. We want to give them the ability to access those benefits, but understand that these benefits essentially are poverty level benefits. These are benefits that are going to give our kids the safety net that they're going to need as they go forward in life, but they're not really going to give them the lives that we want them to have. The lives that we want them to have are going to be much costlier, and we're going to somehow have to provide for that during our lifetime and beyond our lifetime. So as long as I'm alive, as long as my wife, Susan, is alive, we are going to provide for Liz with our own assets, with our own income, and we're going to buy her whatever she needs. I'm currently paying her rent. I don't give her the money to pay the rent. I pay the rent directly to the landlord of the building that she's in. She needs a new iPad. I go out and buy that for her. She needs clothing. I buy that for her. So I am using my money to supplement her income and her benefits to give her the life I want her to have. The problem is what happens when I am gone, when I'm no longer here. How will she continue to receive this ongoing supplemental care? And the way that's going to happen is because I've set up what's called a third-party special needs trust. Now, just be aware, it's called different things in different states. So what this trust will do is it's going to address the ongoing future needs of my daughter, Liz, through this vehicle that I am setting up for her now. It's not going to disqualify her from any of the benefits that she is currently receiving. So the way my estate plan is set up is when I die, my assets go to my wife, Susan, or if Susan were to die first, her assets would go to me. When we both die, our assets will go to our two children. Half will go to Jessica Ehrens, and the other half will go to Elizabeth Ehrens. But Elizabeth will get her half in care of the Elizabeth Ehrens Special Needs Trust. The money essentially at our joint deaths will just plop into this trust, and this trust will essentially be locking up the money for the use of her, and I should say it'll be through the use of her trustee, the ability of her trustee to access this money for her benefit. So the way this works is that I have designated trustees to distribute this money for her benefit. So right now, my trustees are my brother-in-law, Gene, and my brother-in-law, Mike. So when Susan and I die, we will fund this trust with our assets, the assets we've designated to go into this trust, and they will be in charge of distributing this money for the benefit of Liz. Now, just like Susan and I currently, they're not going to give this money to her directly. What they're going to do is they're going to use this money to provide her with all the things in life that we were providing for her while we were alive. So they have what's called a fiduciary responsibility to distribute this money for her benefit. Now, this is great. I have two people today that I trust to distribute this money. The problem is we're all much older than Liz. So I am going to have to change the trustee at some point in the future to someone who is going to be a contemporary of hers, because I'm not anticipating funding this anytime soon. I'm hoping to live for another 25 or 30 years, at which point the trustee is going to have to be a contemporary. Who might it be? It might be her sister and her sister's husband. It might be a cousin of hers. I like the idea of having two trustees because there are no trust police driving around making sure that the money is used appropriately. The trustee, like I said, has absolute and total discretion. They can take the money out of the trust. They can use it however they want. They, again, have this responsibility to use it for Liz's benefit, but that doesn't mean that they will. So we really need to find someone that we can absolutely, totally trust. Now, sometimes families that I work with don't have anyone that they can trust. So what they do is they might use a professional trustee. That could be an attorney, it could be a financial institution, it could be a bank. So there are professional trustees out there, which are good from the standpoint that they will last into perpetuity, but are very inflexible in terms of doing things that might not necessarily be things that you think about when you're alive now, but might be things that you might want to use the money for in the future. So a professional trustee will live by the letter of the trust. Whatever the trust document says, that's exactly what we will, what they will do, and essentially will have limited or no flexibility relative to that money, which may be a good thing, but that's just the way it is. The money in the trust is also protected from creditors and predators, which, so for example, if Liz were to get sued for whatever reason, the money can't be touched. These days of sophisticated phishing and email hacking, it's very easy to find predators out there, especially with our trusting kids with special needs. So the money is locked up in this trust from the predators. The money's also locked up from a potential ex-spouse. Say she does get married and then she ends up getting divorced. Well, that money in that trust is protected from that ex-spouse. The money is also protected from Liz. So for example, Liz will never be able to manage the money that's going to be left behind in this trust. So she really has no control over this money. She has no access to this money. It's controlled solely through the trustee. So because of that, it's protected and we don't have to worry. Like I said, we typically recommend you fund this at death. And there are really two different types of trust. One is called an inter vivos trust, and the other is a testamentary trust. So I have what's called a testamentary trust, which is essentially embedded in my will. And when we die, it pops to life. The executor of my estate puts it into force. It then is funded with my assets, and the trustees will then manage the money and distribute it for Liz's benefit. The alternative to that is called an inter vivos trust. An inter vivos trust is a trust that's essentially alive today. So that would mean you could set the trust up today, you could go down to the bank, you could get a tax ID number, and you could start putting money into it. Now, there are different reasons why you might have one or the other. The biggest reason for the inter vivos trust is because somebody wants to fund the trust now. So in many cases, you have grandparents out there that want to leave money behind for their child with special needs. If that were the case, we might recommend setting up the inter vivos trust. So when they die, the money would go directly into that trust, and everybody in the family could point to that trust in their will. One of the things that tends to happen is grandparents can really screw things up. Grandparents have a tendency of loving their grandchildren more than they love their kids and wanting to leave money behind. So if they don't trust their kids to leave the money to the grandkids, an inter vivos trust would be an appropriate type of special need trust to set up. When you fund these trusts, they can be funded with an unlimited amount of assets. So as much money as you want can go into these trusts. One of the things people don't realize is that trusts are taxable entities. People think, oh, the trust fund is a tax-free entity. That is not the case. Trusts are typically taxed at the highest rate in the land. Essentially, the first $12,000 or so are taxed at the marginal tax rates that are incremental as you go up in your income. But once you get to about $12,000 of income, the trusts are taxed at the maximum rate. So right now, the maximum federal rate is about 36%. In Connecticut, we've got about a 6% state tax rate. There's also the Medicaid tax. So it's possible the trust could be potentially taxed at maybe 50% of the earnings above $12,000. So we have to think a little bit about that as well when we're doing our planning. As I mentioned before, if we use a trust that's set up appropriately, correctly, then the beneficiary, our kids, will be able to maintain whatever benefits they're getting. And the trustee is typically going to provide these benefits, these payments, with the money in the trust directly to goods and services providers, not directly to the beneficiaries. They will not be giving the money to our kids. They will be giving the money to whoever we so designate that we want to have these monies. Otherwise, if the money got into our kids' hands, then they would lose whatever benefits we fought so hard for them to get. So what happens when the money is in the trust? Well, we can use the money really for anything that we want: supplemental medical care, transportation, rehab, education, entertainment, home health aides, trips, vacations, computers, other equipment. Essentially, we can use the money for whatever purpose we deem appropriate. And again, I've written at the bottom of the slide, avoid putting assets in the name of the individual with special needs, because if we don't do that, they would then be disqualified from receiving the benefits. Okay, so that's kind of the way the special needs trust works. And I've just gotten through telling you that you can't have any assets in your kids' names, because if you do, they're going to lose whatever benefits that you fought so hard to get. And if you haven't already started fighting for benefits, what you're going to find is that it's an ongoing, lifelong struggle to get benefits and to maintain those benefits for our kids with special needs. So back in 2016, under the Obama administration, they developed a special account out there called an ABLE account, which essentially, for the first time ever, was an account which allowed our kids to take some money and put it into this account, which essentially would encourage them to have some savings, which might give them a better quality of life and also give them some independence. And these accounts, these ABLE accounts, are essentially developed so that our kids will not lose their SSI and Medicaid. So if you open one of these accounts, they will continue to be able to receive these benefits. Whereas in the past, of course, our kids would be disqualified from receiving these benefits. So that's obviously a great thing. So how do we determine whether or not our kids are eligible? Well, first of all, to be eligible, they have to have had the onset of this disability prior to age 26, which I think in all of our cases is not an issue. If they're receiving SSI or Medicaid, they're automatically qualified. Or if they meet the Social Security definition regarding significant functional limitations, they would qualify. Or if they receive a letter of certification from a licensed physician saying that they have a disability, they would in fact be certified. So if they then become eligible, they can then open one of these ABLE accounts. So these are run by the same people that are running the state-sponsored 529 plans, and there are currently 46 states that are offering these ABLE accounts. You, mom and dad, grandma, grandpa, aunt and uncle, can contribute a total of $15,000 a year. That's a total contribution, all combined of all contributors, of $15,000 a year. That's it. you can only have one account per beneficiary. So if multiple people wanted to contribute, have to let everybody know that this is the account, this is the state that the account is in, and the maximum amount contributed can only be $15,000. The money in these accounts will grow tax-free, which is a great benefit. I see the account that I've set up, and I actually set up the Ohio account. You can set up any account in any state. Over the last 12 months, the investment return is about 30%. So it's up 30%, and that growth is tax-free. There are multiple investment options, and they vary by state, and the fees vary by state. So there is a National Able Account website, which I can send everyone the link to later, which you can look at and you can compare state by state to see which state looks the best for you. One of the nice things about these ABLE accounts is some of the states, not all, have a debit card. So Liz's account, which is the Ohio account, has provided her with a debit card. So while we have a significant amount of money in the ABLE account currently, she has a debit card, and on that debit card, I put no more than $400 at a time. So that way, $400 is the maximum amount of money that's at risk. So she uses that debit card when she goes to ShopRite. She uses it when she goes to the mall. She uses it at Target. She goes out to dinner with a friend. She uses it. And this is her primary vehicle for her to spend her money. Now, one of the negatives about these accounts is they can only grow to $100,000. If they grow beyond $100,000, SSI is then suspended. So these accounts were really designed for our kids to have accounts like a checking account. It's like an ongoing working account to spend money that they would have and they can use to give them some kind of independent life. And again, these accounts are not considered when determining eligibility for any of the programs that are out there. The money in these accounts can really, like the special needs trust, that can be used for pretty much anything: education, housing, transportation, personal support services, health and wellness, financial, legal, employment. You know, Liz uses the money in this account essentially for anything at all that she wants to spend money on. Like I mentioned before, there's only one account per beneficiary. And unfortunately, these accounts have what's called a payback provision at death. So what does that mean? That means if and when Liz were to die, if she were to die and there were money left in this account, whatever money was left in the account would be used, would essentially be grabbed by the state and federal government, and that money would be used to pay back the state and federal government for any monies they laid out during Liz's lifetime to provide benefits for her. So Liz has got a ABLE account. Liz has got a special needs trust. Susan and I die. We fund the special needs trust at our death. Liz then, if she were to spend all the money out of the ABLE account and spend it down to zero, then she should appropriately go and start drawing money out of the special needs trust. And then when Liz dies, whatever money is left in the special needs trust would go to whoever you, or in my case, what my wife and I designated as our beneficiaries of that trust after Liz is no longer here. So currently that beneficiary would be Elizabeth's children if she had any, but if she didn't, it would be her sister Jessica and then Jessica's children. So we spend the money first out of the we spend the money first out of the ABLE account. There's nothing left to pay anybody back with. Then we spend the money out of the special needs trust. Liz dies. The money that we've worked so hard to earn then stays in our family and goes to the other beneficiaries of the special needs trust. There were some tax changes in 2018, which significantly improved the ABLE accounts. First of all, you're allowed now to roll money from your 529 account into an ABLE account. So a lot of families had these 529 accounts, which were disqualifiers for getting benefits, but now you can roll them into the ABLE account. So this is a nice little feature. The ABLE account also has a work contribution amount in addition to the $15,000. So previously I said, well, you can only contribute $15,000. Well, that's gifting of $15,000. That's SSI contributions of $15,000. But Liz can contribute up to $12,140 of any monies that she earns every year. So when I'm making a contribution to her ABLE account, it's asking me, is this a work contribution or is this a gifting contribution? So between the two different amounts, we can actually contribute up to $27,000 a year. Okay, so that's the story on special needs trusts. That's the story on ABLE accounts. So a letter of intent is also an important document that you would want to provide to the guardian of your child in the unlikely event that you were to die prematurely. And it's a non-legally binding document that essentially lays out all the things that you spent your life learning about your child, who your child's doctor is, what foods they like to eat, what medications they take, who their friends are, what they like to do, what TV shows they like to watch. So we used to have our letter of intent on my laptop. I would update it every year. And then I would just shoot an email off to my sister, her guardian, so she would put it in her files so that in the unlikely event that my wife and I were to die prematurely, my sister would know all the things that I've spent my lifetime learning about my daughter, Liz. So I would highly recommend this if you have young children, if you have children who cannot advocate for themselves. This letter of intent is a very critical document. Guardianship. So we are guardians of our children until they turn 18. Once they turn 18, you actually have to file for guardianship. And if you don't, your child is essentially emancipated and they are themselves, and we have limited or no control over their situation. So in order to file for guardianship, you need to file a petition to the court, and the court will then review the petition to determine if your child is legally incompetent. When you are guardian of that child, you become a guardian over their entire person or their property, or both. You would need a certification from 2 doctors, and there's typically a hearing, and the child would essentially assist in that determination. If you become a guardian of your child after 18, you would essentially be making all decisions regarding their future, about themselves, the finances, the medical treatment on an ongoing basis going forward. Now, a guardianship for your child is incredibly restrictive. Essentially, you've taken all their rights away. What I've done is I've filed for my daughter her power of attorney because Liz is pretty independent and she's able to make a lot of decisions, and I don't want to necessarily be there to make all the decisions. So I've filed her power of attorney. So essentially it grants me, the parent, the authority to act on their behalf when making a wide range of financial decisions, such as paying bills and making business decisions. There's no court involvement. It did require her consent, and we did it in the lawyer's office, and she agreed to it. And we both signed this document giving me her power of attorney, and she can cancel it at any time if she decides that she wants it canceled, and there's no finding of her incompetence, and I can use it to open bank accounts or make educational decisions, apply for benefits, sign a lease. Really, I can use it going to the doctor. I can use it really pretty much anytime I want. I also have for Liz her medical or healthcare proxy, which essentially gives me the ability to make medical decisions for her in the event that she is unable to do so. So this is great. If God forbid something were to happen and she would end up in the hospital, I can make all these decisions without her consent. She is 29, and otherwise she would have to have some kind of documents in place, and it would be a bit of a situation without this medical or healthcare proxy. So I would highly recommend this as well. Okay, taxes. Many of you may or may not realize that the taxes are obviously cut into all of our gross income. In fact, I was talking to my accountant earlier today and upset that I've got to pay my taxes by October 15th, but we all have to do that. But what you may not realize is that we can deduct a lot of our kids' expenses as unreimbursed medical expenses. So if you were to send your child to private school, tuition was an unreimbursed medical expense. So I took that, which was a camp for kids with special needs. That was an unreimbursed medical expense. There were all kinds of expenses, tutors, therapies that I basically laid money out for during the year. They're all unreimbursed medical expenses. And to the extent that they exceeded 7.5% of my gross income, these were then deductible, which in many years was a significant number. So just keep all of this in mind when you're looking at possibly sending your child to a private school and you're sort of looking at what the cost of that may be. Realize there may be some tax benefits of classifying these tuition and school expenses as unreimbursed medical expenses. Okay, so at the end of the day, what I'm trying to do, what we all want to do is accumulate as much as we can in terms of our overall estate, our assets, so that we can leave as much behind for our kids as we can. I mean, the more money that's there, the better, as far as I'm concerned. It'll give her as full and rich a life as possible. So how do I do that? Well, the best way, in my opinion, is by diversifying my assets. So I've diversified my assets with real estate. I have money in the stock and bond market. I have a business that has value, and I have insurance. So by diversifying my assets, I've lowered the risk of not having enough money at the end of the day to fund that special needs trust for the benefit of my daughter. We believe that the absolute best way to fund the special needs trust is with the use of life insurance. Life insurance can provide a lifetime of income for our kids with special needs. It will provide estate tax liquidity, meaning that it's totally liquid, it's totally available the moment that you die. It will prevent a forced sale of assets. Let's say, for example, you were to die and what you were leaving for your child was your home, the value of your home, and it was a depressed real estate market, or even the value of your stocks and bonds and the market were down. You might have to be forced to sell those assets to fund the special needs trust. But life insurance is worth 100 cents on the dollar when you die. It also allows for estate equalization. Many times there are other kids in the family, and we want to treat all of our kids equally because they may be ultimately the ones who are acting as trustees for our special needs child. If we leave all of our money to our special needs child and their trustees, it sets up a very difficult dynamic that could be somewhat problematic. So we can use life insurance to essentially equalize the value of our assets for our children. Life insurance avoids probate. So probate can take 6 to 9 months when you die. But again, we can name the special needs trust as the beneficiary. And the moment we die, it pops to life and the money is there. And it's also estate and income tax free, depending on how it's set up. So when it's worth 100 cents on the dollar, now it's worth 100 cents on the dollar when we die. It protects our earning power. It provides survivors benefits. Some of these policies have an internal account that we call cash value, and that cash value can grow at a nice rate of return, and we can access that along the way for our own benefit if we want. I've used the cash value in life insurance policies to pay for college, and really use it for any purpose that you deem appropriate along the way. There are no restrictions. Life insurance is highly leveraged. You can buy it for pennies on the dollar. It's easy to manage, and again, we can use it to fund that special needs trust, again, for pennies on the dollar. Now, when we buy life insurance, we have to understand that life insurance comes in many, many different versions, and it's a fairly complicated investment vehicle. What many of us may be familiar with is term insurance. And term insurance typically will last 10, 20, or 30 years, and it will typically expire right before we die. So it's inexpensive. 98.5% of it becomes worthless. Most people live beyond it. It's particularly good at protecting our income during our working years. But what we really need is what's called permanent insurance. Permanent insurance is insurance that's going to last our entire lifetime. It'll last if we live till we're 75, 85, 95, 105. No matter when we die, the permanent insurance will last. So there's many different kinds of permanent insurance. There's whole life insurance, which will last our whole life and builds an account inside of it that we can access along the way. There's universal life, which is a policy that we have flexibility to fund whenever we want. This is particularly good for people who have variable income during their lifetime. Variable life is where we direct the investments inside the policy in the stock and bond market. Single life might be a policy on our life alone. Joint life would be a policy on ourselves with our spouses. And this is particularly good for families who have children with special needs. So for example, a policy on my life might cost $1. A policy on my wife's life might cost 75 cents for the same amount of insurance. But if the policy were on our joint lives together, it might cost 50 cents or half the amount that it would cost on my life. And truthfully, my concern is not when I'm gone or my wife is gone. My concern is when we're both gone. So we would typically use a joint life policy to provide the most amount of insurance at the lowest possible cost. So this works out really well for families who have kids with special needs. And as I mentioned before, cash value can also provide lots of flexibility. Oh, the other thing about the joint life that can be nice is that if one of us has a history of a health situation, it can also help us work around the health issue. There's different ways to fund these policies. You can fund them over your lifetime, 10 years, 20 years. There's different types of guarantees in these contracts, and we need to understand how these guarantees work. There's risk. You've got to understand who's taking the risk. What is the risk? Is it a cash value risk? Is it a death benefit risk? Who's managing the policy? Are you managing it? Is the insurance managing it? The insurance company? You need to thoroughly understand how a policy works. To buy insurance, you need to apply. You need to be examined. You'll complete an application. You'll be interviewed. They're going to look at your doctor's records, your family history, your medication use. There's an underwriting system where they're going to score you, and based on the score, that's going to determine what you're going to pay in life insurance. When you own life insurance, you have to understand, and most people don't, that this is a real asset. You need to look at that asset on a regular basis. Is the premium that you're paying, is it level or is it increasing? If it's a term policy, when is it going to expire? Is the death benefit guaranteed or is it projected? Is there enough cash in the policy to sustain it? Can it be replaced at a lower cost? So these are all the things that we need to think about when we buy life insurance. So let's say we go out and we buy this policy and our kids do much better than we ever thought that they would. And we've got this policy and we put it in force, and now it looks like we won't need the policy. So what are our options? Well, first of all, we still are creating wealth with this policy, and we can use this policy for all of our children, not necessarily just a child with special needs. We can always use the policy to give money to charity. We can use the policy to pay taxes. This policy will also take pressure off of our existing assets that might be needed for retirement. Many of the families that I work with want to leave money behind for their kids who don't necessarily have special needs. I mean, we live in a world today where it's brutally competitive to be successful and to make a living. And our typical kids may have difficulty, and we may still want to leave money behind for them. So if we have life insurance, we don't have to save money for our kids. The policy is what will be left behind for the kids. These policies, like I mentioned, some of them have this internal account, and that account can be used to even supplement our own retirement. And again, we can access that cash value for any purpose along the way. Now, some of the other things that you might want to think about are disability. Suppose you become disabled. Disability insurance will protect your income, and you actually have a 5-time greater risk of becoming prematurely disabled than you will of dying prematurely. So if you don't have insurance to protect your risk of disability, just understand that if you become disabled, your income may stop, but all your ongoing expenses will continue. Your mortgage, your funding of your child's future with special needs. How are you going to continue to fund all these various different things in the event of disability? Suppose I need long-term care and end up needing to go into a nursing home. One way to offset that is with the use of long-term care insurance. And this will provide money to pay for that nursing care, whether it be at home, an assisted living facility, or even in your own home. Long-term care insurance can protect against that. There are 4 major rating services out there that you need to look at the ratings when you buy insurance, no matter what kind of insurance it is, and just understand that what you're really buying is a promise from a company that will probably be called upon at some point way out in the future. You want to make sure you know who you're dealing with, and that company is rock solid. Of course, no matter how you decide to fund the special needs trust, it's always going to make sense to start early. The sooner you start, the better the result. Einstein said, the 8th wonder of the world is the power of compounding. And for example, if you were to decide that you wanted to fund $1 million in this trust and you wanted to start saving for that when you were 25, well, you'd only have to save $285 a month. But if you waited till you were 55, you'd have to save $5,430 a month. So the sooner you start, the better the result, no matter what the means to save for the special needs trust, whether it be investing in stocks and bonds or mutual funds or buying insurance. The sooner you start, the better the result. What did my wife Susan and I do? Well, we revised our wills. I designated an executor. That's the person to dispose of our assets upon our death. Trustee, this is the person who's going to essentially manage the trust for Liz when we die. The guardian, this would be the person that she would essentially go to in the event of our death prior to age of 18. And now, again, we have no official guardian for her, just her power of attorney. We set up a special needs trust to be funded at our death. I used a letter of intent for Liz during her childhood that I sent to her guardian every year so they would know all the details about Elizabeth's needs along the way. I established a power of attorney and a healthcare proxy, so I do have some ability to be involved with her life at the level that I think is appropriate. I diversified my assets to protect against a market downturn. And of course, we've had multiple market downturns, and every time one asset goes down, it's nice to have other assets in place to know that Liz is going to be okay no matter what happens in the stock market or the real estate market. I'm using life insurance to provide for her when I'm no longer here. I opened an ABLE account to fund her ongoing expenses in a tax-efficient manner. I have disability insurance, which I've already used once, which will continue to provide the funding of all my programs for my family, for Liz, if and when I were to become disabled again. We have long-term care insurance, which will protect against the brutal costs of ending up in a nursing home, which could potentially deplete my assets down the road. And in conclusion, the setting up of the special needs trust and the ABLE account ensured that Liz's future and well-being is going to be determined by my directions and my input, not left to some stranger who might be showing up at my death, who is clamoring to get their hands on my assets and possibly Liz. So I'm in control. I've made the decisions. I've essentially placed Liz's future in my hands. And when you do all of this planning, what you find is you end up with a tremendous amount of peace of mind. You will really feel really good. You'll be relieved. You'll find that you'll be able to sleep well at night. Here is a list of a variety of resources that you only need to email me. I'm happy to provide to you. And this, again, is my contact information. One of the things that we offer is a free consultation. So just if you're interested, I'm happy to answer your questions. I'm happy to set up a meeting with you, talk a little bit about your situation, and provide for you a consultation, or possibly put a plan together for you in terms of helping you figure out what the future might look like for you and your spouse, or you alone, in terms of your own retirement, what might be left at the end to fund the special needs trust with, what might be the best way to set that special needs trust up would be, how to set up an ABLE account. Happy to work with everybody here and help them with any concerns that they might have going forward. Okay, so that's it for me. I'm going to hit stop share, which I just did. And now I'm looking at people, which is nice. And I'm looking at Sunitha, and I'm looking at Lisa, and I'm happy to answer any questions that anyone might have. That was a mouthful.
That was really helpful, Steve, and I think provided a lot of information. A lot of us have a lot of things to add to our to-do list now, but thank you so much for providing all that information. We have a lot of questions that have come in, so I'll just get started with that. You know, there were some questions about clarifying, you know, whether the 529 accounts disqualify your child from receiving SSI benefits. So can you clarify that, and can you also answer whether you can have both a 529 and an ABLE account, and when you would want to have both?
Okay, so technically, 529 would disqualify your child from receiving SSI. Now, I say technically, that's what all the lawyers will tell you. But technically, the 529 is not necessarily owned by the child. The child is the beneficiary of that account. So it may be possible, if you were to go in and apply for SSI, that you could potentially have a 529 account. They might not ask you if there is a 529, and you could potentially get benefits. However, technically, we typically recommend parents not to have a 529 account because it would technically disqualify them from getting SSI. Now, the ABLE account can do exactly the same thing as the 529 in that it can provide funding for college. However, the 529 has much greater limits in terms of funding. You can fund $15,000 per donor to the 529 account. So multiple people can fund in that 15. So mom could put in 15, dad could put in 15, grandma and grandpa could put in 15. Whereas the ABLE account, the maximum funding is only 15. So more money could go into the 529 than the ABLE account. Also, just so you know, a lot of our kids may go to college. Just because your child turns 18 doesn't mean you have to run down and apply for SSI. If you know your child is going to go to college, you might elect to leave the money in the 529, spend the 529 down, and let's say your child then is 21, is done with the 529, the money has been depleted, they could then go and apply for SSI at that time. Another thing about the 529 is you can roll it into the ABLE account, but only can roll it to a maximum amount of $15,000 per year. So if you had 50 grand in a 529, it would take you over 3 years to transfer that money out of that 529 into the ABLE account. And finally, if you have a 529 account for your child and you want to get it out of their name for eligibility of SSI, you could change the beneficiary of that 529 account. So you could technically, if you have other children, you could change that beneficiary to some of the other children in your family, which would then essentially alleviate this issue for your special needs child.
Great, thank you, Steve. And then just since you touched upon SSI benefits, can you just clarify, there was a question about whether it begins at 18 or any age, and whether, whether you get that stipend starting at age 18?
So it would begin at age 18. You can actually apply for it just prior to age 18, but I would recommend that you get everything lined up before you go in there. You're going to want to bring your IEPs, your medical records. You want to make sure all the assets have in fact been transferred out, that there are no assets in your kid's name now. But technically you can, your child would be eligible starting at age 18. That doesn't, again, mean you have to apply at 18. You could apply at 20 or 21 or even at 25, at any age beyond 18. But you're not going to get SSI prior to age 18. Next.
In what circumstances, if any, can a disabled adult who has been disabled since childhood qualify for regular disability-based Social Security benefits and or Medicare based on a parent's earnings?
So if the parent is disabled, or if the parent has died, or if the parent is out on Social Security, and the child has a disability that was a disability that the onset was at birth, it may be possible that that child can qualify for SSDI. Now, the advantage of SSDI, Social Security disability income, is that the payout is higher than SSI, and also that child would be eligible to receive Medicare instead of Medicaid. So if you can get for your child SSDI, that's going to be a superior benefit to SSI.
Can you explain the difference between a guardianship and a conservatorship, and whether that either of those arrangements covers what you talked about with respect to proxies and power of attorneys?
So, there's a little bit of variation by state. Truthfully, I'm not an expert on how it varies by state, and I would encourage people to use their trust and estate attorney to differentiate between whether or not they want to apply for guardianship, whether they want to apply for conservatorship, or they want to do, as I've done, and essentially get the power of attorney. And also the healthcare proxy essentially allows me to make life and death decisions on her behalf if she were in the hospital.
Can you clarify your recommendation with respect to appointing a trustee and a guardian for your child? Should they be the same person? Should they be different people? How do you think about who you appoint for each of those?
So the guardian, I would appoint as someone who truly loves your child and is going to care for them beyond a reason of a doubt. The trustee, on the other hand, could be the same person, but is typically going to be someone who has some financial savvy to them, because they're ultimately going to be managing the money that's in the trust. And by the way, being a trustee requires somewhat different skills than being a guardian. A guardian is someone who might be involved with the child's day-to-day life, making decisions for them relative to where they're going to go to school, what doctors they're going to see, whereas the trustee might be deciding where the monies in the trust are going to be invested, filling out the trust annual tax return, and distributing that money for the benefit of the beneficiary. So the answer is, it can be the same person or it can be the different person. The only recommendation I would make that I think is critical is that there be two trustees to the trust, not necessarily one guardian, but two trustees. That way, neither one can act alone. They both have to act together. And everyone's always heard of the stories where the trustee has run off with the money. And that's because they have total unfettered access to the money. There's typically a trust account that's set up with check writing capabilities, and they can write a check to themselves if they wanted to and just take the money and run. So trustee means person that you can trust.
Last question I have
Yeah.
before we wrap up is whether a contribution to the special needs trust would qualify for the gift tax exclusion.
So you're allowed to make a gift to anybody of $15,000 a year, and you don't have to report that annual gift. So when you're making a gift to the ABLE account or the Special Needs Trust, you're essentially making a gift of that $15,000. However, when you're funding a Special Needs Trust and you're funding it with gifts, not the ABLE account, but the Special Needs Trust, typically that gift you would have to report as a gift through your total lifetime gift tax exemption amount. Because when you're making a typical gift to a trust, you're typically also sending out what's called a crummy letter. And a crummy letter is essentially a letter to the beneficiaries of the trust stating that they have the right to spend that money. If you give the special needs beneficiary the right to spend that money, then you're essentially giving them that money, and that would then disqualify them from receiving their assets. I'm sorry, receiving their benefits. So it's a little bit more complex than a simple answer, but simply put, you can give $15,000 a year into the ABLE account. That's within your annual gifting amount that's allowable, and that will not preclude your child from receiving any benefits. If you were to gift the $15,000 a year into the Special Needs Trust, you would have to, and you could gift more than that into the Special Needs Trust, you would have to fill out a gift tax return. Otherwise, it could be construed as their crummy rights, which would then disallow them from receiving benefits. Hope that answers the question. It gets a little bit complicated with the gifting, but it's important that it's understood and handled correctly, because if it's not, then they could be disqualified from receiving the benefits.
Great, thank you so much, Steve. And as Steve mentioned at the end of his presentation, if you want to follow up with Steve, feel free to shoot him an email or reach out to your own personal tax advisor to get clarification on any of the information that was covered today. But we so appreciate you spending your time today with our community and helping answer these questions and keeping us informed on all of these special needs financial planning issues. Thank you, Steve, and thank you everyone for joining us today.
Thank you all for having me. I appreciate you spending the time with me, and I hope the information I provided you was helpful and informative.